Great. Anyone, I have a few issues, but has anyone got anything that came up for them this week that they have a question about that we should deal with? Nope. Okay. We had an interesting thing come up this week, and I've got to go in the background here and pull up zip forms. So hold on while I do that. I'm sorry, didn't have the time to do that before. Anyway, the issue had to do with a very rare thing came up where a paragraph in the RPA deals with it, but it, I haven't had this question. I can't remember last time it came up. So it had to do with keys, key delivery. And it happened to be, we were representing the seller, and the seller was an investor who had owned this property in a PUD or a condo and had rented it out. And so it was previously rented. And when we got to closing, they gave us what keys that owner had, which was a key to the unit. But they didn't have keys to the pool, the common area pool, or the, get this on screen here, okay, or the mailbox. So we went to the RPA, which, let's see, you all see that? Give me a nod. Yeah. Okay. Thank you. So we went to the RPA, and it's paragraph 9F. Here we are, 9F. At close of escrow, unless otherwise agreed in writing, sellers shall provide keys, passwords, codes, and other means to operate all locks, mailboxes, security systems, alarms, home automation systems, and intranet and internet connected devices included in the purchase price, and the garage door openers. If the property is a condominium or located in the common interest subdivision, the buyer may be required to pay a deposit to the homeowners association to obtain keys to accessible HOA facilities. So seller didn't have those keys. The seller had only the house key. So, and we said, well, the buyer's agent was complaining, you got to give us keys, you got to give the keys, you got to find replacement keys. You got to go get the replacement keys. And he said, no, it says we give the keys that we have, we don't have them. So as a practical matter, the buyer should really go get what keys he or she needs. And if he thinks the seller is liable for that financial cost, and then send the bill over, and we'll give it to the seller and see what the seller does. But as a practical matter, you better not wait for the seller to do anything. The buyer needs a mailbox key, and if they want to go swimming, they need a pool key. So it was interesting that the homeowners association sent the buyer a form to sign so the buyer could go in and get a key, for the common area. Well, what did they do? They mailed it to the mailbox, and then the buyer didn't have a key to the mailbox. So it's like, this catch-22. And we said, well, take your closing statement and send that off to the homeowners association and ask them to send you the form wherever you need it, or what, however it can get done. and carry on. Now, it's interesting because, again, I haven't heard of this in the past, and maybe some of you have had transactions where there's been a key deposit, and if I may have a key deposit here, I don't even know because I live in a common interest subdivision. But if I have $100 there in the deposit and I return my key when I sell the property, they would give me the $100 back. It'd be my $100. And the RPA says that the buyer may have to put his own $100 up there, that my deposit doesn't transfer to the buyer. Has anyone had that circumstance come up? No. Well, like I say, I haven't heard of this issue for years. Maybe the first time I've heard of it. So um, that's how it got dealt with. It was the buyer's agent was kind of unhappy for a little bit, and we just said, hey, move on. Yeah, we got better things to do, because our agent, was taking on the responsibility. Do I have to go get the keys? And I said, no, that's not your job to go get keys. You go find a new buyer or a new listing. I don't want you going to get keys. So and that was that issue.
I had an issue with the mailbox key.
Yeah.
I had an issue with a mailbox key. The seller didn't, same thing, tenant had a tenant, didn't realize they didn't have a key until closing.
Yeah.
And the post office will not allow the previous owner to get a new key. They have to go drill it out and what have you. And it has to be done by the new owner if it's already transferred. So the previous couldn't do it anyways.
Yeah. Okay. That makes sense. Thank you. We have an $8 million listing, and a licensed agent who specializes in kind of, this a winery property with a home on it, specializes in that kind of, well, they're a member of Norbar, but not of Bayris. Okay, they don't belong to the MLS because it doesn't have the type of properties this particular broker uses. So it's interesting because through Bayris is where we offer compensation to a cooperating agent, right? So we put our listing in there, and we put in the box with, in Bayris that we're offering 3%, we're offering 2.5%, or whatever it is we're offering to the cooperating broker for the sale of the property. And that is binding on us, that offer, because we're members of Bayris. And if, Sabrina is a member of Bayris and she brings us a contract and we've offered 2.5%, she's entitled to that 2.5%. Of course, comes through the broker, but anyway, he's not a member, so he's not protected with that offer of compensation. So the question came up, well, how does he protect himself in relating to the compensation? You could probably already guess what that would be, but let's see. We'll go back online here and sort by A to Z, and we'll look for commission agreement. So there's this form called commission agreement. Yeah. Okay, so and this is used when there's no other binding agreement relating, like the MLS, relating to the commission. We use this also, like, let's say you're going to write an offer on a FSBO, and the FSBO says, well, I'll pay you 2%, or I'll pay you 3%, or whatever it is. Commissions are negotiable and not fixed by law, right? So if we're going into the FSBO and we get our buyer to write an offer, we write up the offer for our buyer, and we write up this commission agreement. And the procedure is we give this commission agreement to that FSBO before we give them the offer. because the offer doesn't say anything about paying commissions. The RPA doesn't really have anything. Other, it may refer to the commission in the MLS. Well, it's not in the MLS. So we would use this form, and if the owner, the FSBO, doesn't want to sign it, then we say, well, we're not going to give you the offer then, because you said you'd pay us this, so we're just confirming that. And this can be related to a principal. You would put in the name of the seller here. And then our brokerage would go here. Let's see if there's a drop down here. Yeah, there we go. Take out the global banker part. Anyway, and if we're going to relate, limit this to the one party we're bringing the offer in on, we could put that here in other terms, subject to the broker bringing an offer from Chris Brown. Chris happens to be one of our GCs. I don't know if you're on here, Chris. So that's how we would handle that commission agreement form. Any questions on that? Okay.
Gary, I have a question.
Sure, Brian.
Would this same apply to making an offer on an off-market property?
Yeah, that's not in the MLS. Any property that's not in the MLS, you would want to get that commission agreement signed by the seller before presenting them an offer.
Okay, thank you.
Gary, I had a question.
Sure.
Where and how would you address and codify agency? If you're going to represent the seller only or the buyer only, or represent both, where is that going to be defined?
Well, it'd be defined in the RPA, and you need to determine that in advance. Of course, we'll go back here to our RPA form. Oops, that's residential listing. Sorry. In your RPA package, when you write that offer for the buyer, even if it's an off-market property or a FSBO or whatever it is, you're going to have your agency disclosure. So you're already going to determine by talking to both the buyer and the seller whether you're representing both parties or just one or the other. You would do it there in the agency disclosure, and then again here in the confirmation, agency confirmation.
Yeah. Okay, super.
Okay. Any other questions? I'll stop share there on around that matter. So we had a lengthy dialogue, let me call it, around an unhappy seller with whom we have a listing, and the agent called, and they've worked on this property for months, getting the listing ready and getting the photographs taken and everything, and discussed with the seller, pricing strategies, and they had a CMA that had a recommended price, and that they went to the seller with, and the seller says, no, I want to get more. And they discussed the possibility that, well, if you listed it at the market price, you might get competitive offers like Eric did. You might get more than one, or like Liz just did. She got 12, if you price it at market, and the market responds to it aggressively. It wasn't a particularly property that was going to be everybody's cup of tea. It's a 0 lot line development with only 2 bedrooms and blah, 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 blah. And there are some comps, and it was, priced aggressively relative to the comps. And our agent went over the advantages of pricing it at, 3% less than the last comp, as Randy always says. But the seller wanted to be more aggressive. So the seller went out on the market. They said they were going to take offers, a week from the day it was listed, Monday at 5 p.m. Well, comes Monday at 5 p.m., they have one offer. And that was over the asking price. But as soon as that buyer's agent, they asked her, are there more than one offer? And they were told, no, you're the only offer. We will work with you. And they said, well, that buyer withdrew their offer because they only offered more than asking price because they thought they'd be in a competitive situation. So now that, that took the seller off, royally, and they had a good offer that just kind of withdrew itself right away. The short story is the seller wanted to cancel the listing agreement. And it was really, the agent asked me and said, hey, I got this email, and sent me the email and says, the seller wants to cancel the listing agreement. But this is after they reduced the price from the original asking price down lower in hopes of getting a more immediate and satisfactory offer again. And in fact, during this, prior to the seller asking for the cancellation, this buyer once they reduced the price, the buyer came back at lower than the reduced price with the new offer. So yeah, so the seller is really kind of unhappy with how this thing's going, but it's, it's how the market's responding. So she asked me, because this offer was still in place, she says, what should I do about responding to the seller's request to cancel the MLS, cancel the listing? I said, well, do you want to cancel the listing? It sounds like a very difficult seller you're dealing with. Do you want to cancel the listing? And she said, no. And I said, well, how long is the listing for? She says, 1 year. She got a 1-year listing. I said, you have exclusion in the listing for parties that have seen the property in case we do cancel the listing. You've got protection of those parties. And she had a 90-day protection period in the listing agreement, which is all good. And I said, well, if you don't want to cancel the listing, I would just wait. Don't respond. I call it, I learned it from a therapist, actually, and it's called gray rock. She calls it gray rock. Just be a gray rock. You didn't hear it, you aren't responding. And see where it goes. I've learned over time, I've learned over the years that time solves a lot of problems, particularly overnight. I said, let it go overnight, and we'll see what happens with the new offer tomorrow. We'll see, maybe the buyer, seller is in a bad mood, and this and that. So of course the seller kept sending notes to the agent, hey, we need to talk. I want to cancel the listing, blah, blah, blah. And I said, just wait. We don't have to respond to that right away. So the next day she said, the seller says, well, I'm going to call you a broker. So she does call me. And I did a little gray rock too, because I knew that our agent was trying to then establish a phone call with the seller. So I just waited. And of course they talked for 2 hours, and then they were going to talk again at 3 in the afternoon. They talked in the morning, and long story short, they worked it out. So, by kind of letting things unfold kind of naturally, my former partner and mentor and good friend, Earl Shuttleworth, one of his favorite sayings was, letting things effortlessly unfold. It will unfold the way it is. We have a binding contract, but I didn't want to rub that in the seller's nose and just get her more agitated. So we stayed away from that issue. I did write her an email and said, hey, you have this offer. I understand you have this offer. I also understand you asked about the cancellation, and we can deal with that later, but what do you want to do about this offer? Because it has an expiration. So anyway, it unfolded, and now they've reached agreement on how to communicate with each other, because that was the basic problem. They had very different communication styles. So maybe a little time sometimes helps solve these issues. I found that to be true. Sabrina, did you have a question? No, I thought I saw you wave your hand. Yeah, you were just saying hi. Okay. Another thing that came up was we have a previous listing. We have a new listing. We took a listing on a property which we sold to that owner some years ago. And then we helped that owner with some issues that were in that contract when they bought it. And we still have that information. So do we give that to a new buyer? And the short answer is the one Bill always gives, Bill Jansen, our risk management attorney, which is if you have it, you give it. So you have the disclosures from the prior transaction. I don't care if it's 10 years ago or, if you have it, you give it. And that will actually come up in part of the standard of care discussion we'll have in just a minute. But just remember, if you have it, you give it. You have the information, you give it. Remember that his other determines you disclose, you the credit to whoever you got the information from, and then you disclaim any further knowledge of what it's about. So you disclose, I got this information from the prior purchase. It came from our old file. I don't know anything more about it. That's kind of the three-legged horse there. Mari, you have a question? Mari, got to just.
That helps, doesn't it? It's amazing
Yeah.
what a difference that makes. The first thing, I've found, I've done this now for quite a few years, that I can pretty much tell as I'm talking to the new buyer that I'm representing, and whether, I can sense whether they're going to be kind of squishy or not down the line. And partly because they'll usually talk about other, transactions they've done, and you hear about how they've treated other agents and stuff. So I think that's a really good way to just, kind of, can have your little tentacles up and go, okay, this isn't me, this is them, and this is how they're probably going to react. But so that's just one comment. And then the other one, how long are we supposed to keep stuff? I still have paper files I need to have shredded from a million years ago, but I thought I'd heard something about that we were supposed to, you send stuff into the transaction coordinator, and then you don't keep anything else on your computer. Is that correct? Because are we supposed to keep it on our computer?
No. Our legal counsel suggests that once we have the broker file complete with everything we need in the broker file, the broker's obligation is to keep the files, I think 3 years. We keep them 7 years.
Okay.
And you should probably destroy your paper file and erase your emails and stuff like that, because if you get called into court on anything, they're going to be subpoenaed, and you're going to have to dig them up and produce them. And I think I described that case where an agent was with us at the time and had since left, but she still had the file from a transaction 10 years ago. And we didn't, because, the statutory period had passed, but she had to produce all the documents from the file. So her file, because she had it. So it could be more of a burden than not if you maintain those files.
Okay, good to know. Thank you.
Righto. Okay, so a little bit on standard of care, and then Heather's going to follow up a little bit on this topic too, because standard of care is like a really big issue. Whenever I do training, I start with this agency disclosure, Go back here to Shane, to your screen. I mean, this form was put into place because there was a lawsuit. Of course, it was against Coldwell Banker. All the lawsuits in California ended up being against Coldwell Banker. But that's just an aside. But this was written into the civil code, and it was written into civil code by CAR. It was promoted by CAR. Our legislative team took it to some legislature, and they passed it in the civil code. And it explains in detail the agency relationships, because we didn't have this form before, and it was obscure. And one reason was because the way the industry is structured, the payments are all going to the listing agent. The listing has the agreement with the seller, and then it's going to get paid. And then the listing agent agrees to share it with the buyer's agent. So in the past, and the genesis of this lawsuit was that the buyer was unhappy with their own agent, but sued not only their own agent, but the listing agent, because the listing agent was the one who got the commission. So this form was generated to make it clear who we're representing. And the duties we have. So if we're the seller's agent, we have the duty of being a fiduciary duty of utmost care and integrity, honesty, and loyalty, dealings with the seller. And I always describe fiduciary as like the trust, you hold a trust fund for someone's child, you're responsible for it. Or you're on the hospital board and you're using public funds, and you're responsible for it. It's a very high level of responsibility, this fiduciary stuff. And then to both the buyer and the seller, you have these duties of diligent exercise of reasonable skill and care to performance of your agent's duties, a duty of honest and fair dealing in good faith. Good faith is an interesting question. That always comes, were we operating in good faith? Were the parties operating in good faith? And a duty to disclose all facts known to the agents that materially affect the value or desirability of the property. Those are very important words. Anything that materially affects the value or desirability of the property that are not known to or within the diligent attention or observation of the parties. So we know something they don't know and they can't find it out, like these prior disclosures. We know them, so we have a duty to disclose them. An agent is not obligated to reveal to either party any confidential information obtained from the other party that does not involve the affirmative duty set above. So, and then the flip is, same thing if we're representing the buyer only, and then, you times it by 2 if you're representing both the buyer and seller, and that means our brokerage representing both the buyer and seller. It could be 2 different agents, but the brokerage is the same. We have this double duty to each. And if you're singly representing both the buyer and seller, you're really at the highest level of standard of care as an individual in a transaction. This industry is different because the attorneys can't represent 2 sides, even if they're mediators, they aren't representing either side. But an attorney is an advocate for one party and not the other. In our case, we're allowing ourselves and our brokerage to represent both parties and give them both fiduciary care and so forth and so on. So that's those are really high standards of care. Now, going to the standard of care issue itself, we got this weekly practice tip. So what is standard of care? It's a legal term that used to describe one of the basic elements in a claim that a party was negligent. And it's a civil code spells out, defines negligence. Negligence is a failure to use reasonable care to prevent harm to oneself or to others. So this just isn't real estate negligence. This could be driving negligence. It could be, you know, an accident that happened, you know, and you were negligent for not repairing a step or something like that. This isn't just real estate stuff. And a person can be negligent by acting or failing to act. So we could make a negligent act, or if our failure to act could be negligent. A person is negligent if that person does something that a reasonably careful person would not do in the same situation, or fails to do something that a reasonably careful person would do in the same situation. So let's say we need to be reasonably careful people, and that's our standard of care. CAR passed, besides the transfer disclosure statement, they added the AVID form to the civil code, and on our behalf to protect us. And that civil code says the standard care owed by a broker and vis-a-vis by the agents is the degree of care that a reasonably prudent real estate licensee would exercise, and is measured by the degree of knowledge through education, experience, and examination required to obtain a real estate license. So they're going to take into account what a reasonably prudent real estate licensee would do. So, you know, we all need to be reasonably prudent real estate licensees. And we need to expand our knowledge through education, experience, and examination. And it's not just what's required to get a real estate license, because we know we can take 30 hours of the course and take the test and get our real estate license, but that's not experience, right? That's just an exam. So it's really this education and experience part they're going to look to. If you're an experienced agent, like many of you are, you know, you're going to recount how you know you've worked over the years and what's been your practice, what's been your standard of care, or how you practice your business, what education you have. You know, you've taken the recent ethics course and it told you this, and so forth and so on. So she repeats here, you know, there's many places where we are bound by standard of care, statutes, the appellate decisions, contract clauses, custom and practice in the industry. And the thing is that if it's alleged that an agent breached a legal duty, which are like we were negligent, then that legal duty was owed to a party in a real estate transaction, the standard of care would be used to determine whether the agent actually acted reasonably in performance of their duties. And what happens is when we get called in on one of these cases, somebody claims we were negligent and we breached our fiduciary duty and stuff like that. It's not nice stuff. The arbitrator, judge, or jury will decide whether the agent met the standard of care. And what they do in these cases is the one side gets what's called an expert witness on the standard care issue, and the other side gets their expert witness on the standard of care issue. I've been asked a number of times to appear in court as an expert witness and testify to whether the client, you know, the agent exercised standard of care. And I remember the only case we ever took to trial, our expert witness on standard of care had a total different opinion than the plaintiffs. We were the defendant, than the plaintiff's expert on standard of care. So, I mean, that's kind of confusing to a jury who doesn't know anything about the business. So, to assure yourself that you are meeting the standard of care in your transactions, you should ask yourself the following 4 questions. Am I giving the clients the utmost care, integrity, honesty, and loyalty at all times during my relationship with them? With respect to both clients and other parties in the transaction, am I acting honestly, fairly, and in good faith? Am I being diligent in the representation of my client and the performance of my duties? Am I exercising skill in the way I handle the transaction? And again, our skill levels vary. If you're a brand new agent writing your first contract, you're going to want to work with your mentor or me or Randy or someone to see that you're not only have your skill involved in the transaction, but you're borrowing the skill of others. Sometimes the new agent will say, well, I really don't have much knowledge here. I said, yeah, but your company, your brokerage has a huge amount of a vast reservoir of knowledge. Draw on that, use that. That's why we're here. Any agent will help you if you ask them a question, and any experienced agent will give you help. Am I demonstrating care in the manner in which I prepare and deliver documents, in the way I communicate with my client on the other side, and the accuracy of my paperwork and communications? I think we're in a mediation right now, and Randy's handling it with our agent, where the seller's agent had a disclosure item that they sent along in a second communication of disclosures. They had given us original disclosures. This was a new disclosure, but they stuffed it in the packet of all the disclosures that had already been given, some 40 or 50 pages, and it was stuck in there as a one-page document with new disclosures. So when we got it, and we saw it was the same disclosure package that we already had, or it looked like the same, and this new disclosure wasn't highlighted by that agent, it got ignored, and the seller or the buyer found out about it and said, hey, I didn't know about this. And the seller's agent is saying, well, it was in that package we sent you. Well, the standard of care, in my opinion, in that case would be, if you have a new disclosure, you have to set it out as a new disclosure and just not put it in a stack of papers. You've got to specify it. Final question is, am I operating in a geographic area within the type of property where I feel competent and understand the standards to which I would be held? If not, then I will get help or refer this transaction to someone who's competent in that field. So this would apply not only to geographical areas, but what type of property. So if you don't have any experience in commercial property, you come to me, I am going to take a commercial listing. I said, that's great, but co-list it with someone who knows what they're doing. In Lake County, we're very lucky that David Hughes is part of our team now. He's a very experienced commercial broker. And here in the other parts of wine country, Isaac Raboy and Misty Platt are both commercial agents with a lot of experience, particularly Isaac. And I would refer a new agent who wants to do a commercial transaction when they've never done one before to work with one of those people and pay them a referral fee, because in the long run, it's going to protect you from potential liability. You're licensed in the state of California. You want to go sell a house in San Diego, you could do it legally. But if you don't know anything about San Diego and the standards of practice and the standard of care that they use in San Diego versus here, I'd suggest we find someone to refer to and take a referral fee. So that's kind of that's my spiel on standard of care. Thanks for your patience with that. Any questions arise? Yeah, Alejandro, a new agent. So hopefully I've scared you sufficiently.
No, I was just wondering how you talking about the disclosure situation that there was in that package. How did you manage? What happened? Like, okay, you didn't see it. How far can go, or what? How you go back to?
You have first-hand knowledge of this one, Heather? I don't think you're involved in that. No. Okay, so this disclosure package, not only was it kind of delivered in a lump form of 40 pages, it was delivered at the very end of the transaction. So there could be something said that even though it was delivered late in the transaction and it appeared to be the same disclosures that had previously been received, our agent should have gone through it page by page and make sure it was complete. That could be an argument that the other side would have here. But now what happened on the ground was the buyer found out about this issue on the property when they moved on to the property. They said, wait, nobody ever told us about this. And we went back to the listing agent and say, hey, we discovered this, nobody ever said anything about it. And they said, oh yeah, it was in that last disclosure I sent you 2 days before closing. Typically, if it's a seller's disclosure and it's an amendment to their TDS, their transfer disclosure statement, the buyer would have a 3-day right of rescission, which is another reason that agents should have carried that document by itself to us and said, hey, we have this new disclosure besides all the other disclosures that we already gave you. So I don't know where it is, and I don't know the amounts of money involved. It may involve tens of thousands of dollars that the buyer is seeking the seller to reimburse them because of this problem that wasn't disclosed. But it's in mediation right now, and hopefully it will settle without moving further down the path.
Got it. Thank you.
Of all our transactions, and right now we're doing somewhere in the area of 1,000 transactions a year, my experience has been about 3 to 5% of those transactions have something percolating in them. That is, somebody's unhappy after the closing. So there's usually 3 to 5 files that are either on my desk or Randy's desk that are kind of what would you call hot files that we need to notify the E&O company about these, so that if it goes, our obligation to the E&O company is to notify them as soon as we hear of anything, a claim of anything, and then we need to try to settle them. And 99% of those transactions get settled in some negotiation before even going to mediation, and some go to mediation, get settled, and very, very, very rarely do we actually end up in court on one of those things. But that's why we have E&O coverage, because the one time we did end up in court, it was ended up being a $400,000 claim. So we certainly we're glad we had insurance. So Heather, is that a launch point for what you wanted to cover?
Yeah, perfect.
I've made you co-host so you can share your screen.
Okay, great. Thank you. So as Gary said, all of this standard of care, this great tip from our attorneys comes from the National Association Code of Ethics. So I thought I would just show you where you can easily find that. And I didn't hit share, I just changed my screen. That's not helpful. So if you go onto the National Association of Realtors website, NAR, then you can just go right into their search bar here, search for Code of Ethics, and it pops up very easily. It's redone, I believe, every year, just updated, made sure it's still very timely and specific to our current civil codes and everything. And then if you scroll just a little bit here, you can see there's a really easy place to just search the Code of Ethics. So if you have something that comes up that you specifically are wanting to know, remind yourself about, this is where you would go. Very easy to find. And it summarizes right here as well. Articles 1 through 9 are all about your duties, our duties to our clients and our customers. Articles 10 through 14 are our duties to the public. And Articles 15 through 17 are our duties to other realtors. So anytime you have something come up that you are concerned about, or that you want to make sure you're really using your best standard of care, just pop in here and take a look. You can read right through it. There are many standards of practice, and if you're following those, that is what you're going to be able to back up and say, yes, I used a good standard of care, if anything ever does come up. Everything that Gary went through in that practice tip. That practice tip is a really nice summary of those things that we need to make sure those 4 questions are really great to make sure that you are following all these standards of practice. And then there's also, of course, talking about working with the public and other realtors. There's a lot in there as well. From there, I want to remind you all that we all need to have our code of ethics training completed by the end of this year. That's a 3-year cycle. So I know I couldn't remember if I had taken it in 2019. Often it's bundled with other things. There is no charge for it, but I want to show you guys where it's really easy to find out whether or not you have already taken it or you still need to take it. So this is the North Bay Association of Realtors website. And you can come on to the main website, not that North Bay Happenings, right? That's where we access all the MLS, the meetings, and any education. But if you go onto the main northbayrealtors.org, it's going to take you to this home page, and then you just simply log in and you go right here on the left side where it says member portal. You can just click right on member portal, or you can click on access your portal, and then it will pop you over to your member portal. And here is mine, so you can see easily right beneath your photo and your name, it says your COE cycle end date 12/31/2021. So we all have code of ethics that we need to have taken by then. And then it says the last time you took it. I took it in 2018. So is my cycle complete? No, I need to take my code of ethics training. So you can easily go in and look if you don't remember. Probably if you don't remember taking it, you probably need to. So just remember by the end of the year that is a requirement. And it's a really, we all get tired of, God, we got to take our CE, we got to take our code of ethics training again, but it's a really good reminder. It helps us make sure that we do that standard of care that we need to be doing. If you haven't yet taken your code of ethics course, for this cycle, if you just click here on member resources and you scroll all the way to the bottom, there are many code of ethics trainings that are scheduled right now. Just scroll up and they are almost all of them are free. There's a couple that there's a charge. Why not take the free ones, right? But there's one coming in just a week or two. I mean, there's one through North Bay Association every month until the end of the year. So you can easily sign up for it. It's 2.5 hours of in-class instruction. I do believe you have to have your camera on so that they can see that you're actually there engaging in the class. There's a lot of other places as well. The California Association of Realtors. There is this non-CE version. So there's lots of different opportunities. Just make sure you get it in before the end of the year. There's more on the CAR website as well. So.
Great. Thanks, Heather. And Heather serves us all on as a director on the North Bay Association of Realtors. So apropos that you let us know about those things. Thank you. And Heather is a broker, a real estate broker, and brokers are broker associates with the firm, and not, different from a real estate salesperson's license. She is a licensed broker, as I know some of the others of you are too. Let's see, Heather, there was one tech question that actually Eric had this week for me, which I think I stumbled through, and hopefully it worked correctly, Eric, but it had to do with Disclosures.io. And he was up, I think you had uploaded your disclosures to Disclosures.io, and then you were entering the listing in the MLS, and you were looking for a link to Disclosures.io to put into the listing. And I think we determined that there is no link per se, that
yes,
the agents other agents who want the disclosures go on disclosures.io and they request them from you, and no. So you clarify for us, Heather.
Sure, sure. There is a link that you can put the link in. Eric was trying to link it up in right through MLS, and I have to research that. It didn't seem to work, so I'll look into that. But what the easiest thing to do, if you want to include a link in your listing, is, let me just share the screen. It's not the most logical place to find it, but let me just show you. So here is Disclosures.io. Here's one of my listings on Ventana. This is just the main homepage on listings. You click the share button. Up pops the share package right where you could put in your TC or an agent. And on the bottom there, on the bottom left, get share link. So you just click on that and it creates a link so that someone could copy and paste. You can copy this, put it into the MLS in your private remarks, and then agents can copy and paste it up into their, into their search engine. I will give you a little tip. This has come up a bunch of times. Let me show you the very end of it. You can see the very end of this. What a lot of agents I've noticed have done is they just automatically, when they're typing, they hit a period, like click here for disclosure link, or here's the disclosure link, and they put a period at the end or a space. And then if people copy that, a period, it will tell them that the package is no longer active. And so if you get a call from an agent saying your link's not working, just tell them. Sometimes what they'll do is they'll copy the whole thing, but they'll have a space at the beginning. So it'll be space and then the link. So just tell them, try again to make sure there's nothing on either side and post it in there. Of course, the other option is you can just get their contact info and just, send it over to them right here and share the package with them directly.
Okay. Let's see, Terry Bell's advising us, if you take the NAR Zoom class for ethics, then you don't have to take a test, just watch the video. Okay.
Oh, great. And if you take the, I forget what it's called, the EX, it's on the bottom of that site. Does anybody know what I'm talking about? What's the name of it? The EX, the National Association, like it's a Realtor of Excellence course that you can have, and you can keep that ongoing. If you do keep that registration, then you don't have to take Code of Ethics ever, because that's part of it. The EX, I think it's EXP or something. I have to find it. If you want to take a second, you can.
So Eric, were you able to find that link? And since I misled you on how to do it, I'm sorry.
I followed Heather's instructions and it was good.
Okay, thank you. Thank you for explaining, Heather.
Yeah. Oh yeah, it's called the C2EX. It's a extra, education you can take for excellence. So that covers the code of ethics.
Yeah, and just doubling back on the standard of care and the education part, you should make it part of your regular practice to take these education courses. Keep yourself up to date. Attend our legal update. All of these things, attend Heather's trainings, which are great. We brought Heather on as a trainer because we feel really, really seriously about the education side of our business. So, take courses and then, I hope it never happens, but if you ever have to answer to someone about, well, how do you keep up to date on the business? And you say, I take a course a month, or I take a course every couple of months, and to keep my education up in these and on the whole industry. So make it a regular part of your practice to take education courses, even if you're skilled. Eric and Mari and others of you have been doing this business a long time. You still tune into these things, and I appreciate that you're keeping yourself current, up to date. I appreciate your sharing your knowledge from time to time as well. Okay, I think that's all we got today. Next week, I'm not available, and Heather's going to run that course on what is it? The AB 38.
Yeah.
You want to announce it again, just in case people watch this and not the other one?
Oh, yeah, it's next Friday at 11. Property ID, Lori Boatwright, and their attorney will be presenting everything you need to know about that new legislation, AB 38, which is the wildfire disclosure and investigation, your requirements. And so they'll let you know everything about that. Obviously, I need to learn about it too. And what you need to do to protect yourselves, your clients, and the company. So make sure
Will you
come
send us a
with
link?
lot of good info. What's that?
Will you send us a link?
I will. Yeah, I'll send out something probably Monday. Well, maybe I'll send out some.
Whatever.
I'll send out things.
Yeah,
Yes,
yeah,
I'll do
that's all.
before as well.
Okay, great.
Yeah.
Thanks.
I'll put it in my message, my Monday message with the weekly practice tip.
Thank
as well.
you.
Great,
Okay.
great, great.
Okay,
Awesome.
any other questions before we head out and go do some business?
Thank
Yeah,
you.
Terry, you have a question or?
I just want to say that I just got an email that I'm very excited about because I took my first COVID test in Roseland because I'm going to go see my grandchildren next week. And I wanted to make sure I'm safe. And I just thought it's so much easier than I thought. And I just thought it might be something that people might want to take advantage of. It only took like a half hour to get through. The line was short in Roseland and it was very easy. And within 2 days, they just sent me an email saying it's negative. And now I can tell my clients that I'm negative for sure, besides wearing my mask and doing all that stuff. So I just think it's something to think about.
Yeah, I was recently in New York City, and they have free testing set up in vans at various sidewalks around the area where we were. So we just stopped at one day, filled out a little form online. They had a little QR code. You snap that, and they pulled up a questionnaire. You fill out the questionnaire. It went to their computer. They took the test. In the morning, we had an answer. It was free. It was very good service. So.
Yeah. So, okay.
Okay, everybody. Have a great week, and we'll see some of you at the party tomorrow, and I look forward to it.
Thank you.
Be well.
Bye, everybody. Have a good one.
Bye-bye.